All rise. Hear ye, hear ye, hear ye. Supreme Court of Florida is now in session. All who have cause to plead, draw near, give attention. You shall be heard. God save these United States, great state of Florida, and this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Judge Contini. Your appearance before the court today marks a sad occasion, saddest of all for the public we serve. The effectiveness of our judiciary ultimately rests on the trust and confidence reposed in judges by the people. You are here today because of ethical failures that had damaged the public trust and confidence. Because no one can undo what you have done, we have commanded you to appear before us in open court. You are here to receive a reprimand that is being broadcast throughout the state. This is a task that I do not enjoy. But it's certainly one that we as a court regard as vitally necessary. It is one way we can assure the public that we take this matter very seriously. We will not hesitate to punish judges such as you in a very public way. You have been found guilty of violating Canon 1, Canon 2A, Canon 3B, and Canon 3E of the Florida Code of Judicial Conduct. The charges filed against you arise from several events. First, they involve an ex parte email you sent to the Broward County Public Defender's Office. Second, they involve your failure to seek either a recusal or a transfer that would have prevented delays in your division. And third, they involve impertinent remarks you made in open court about a pending matter. As to the first matter, the email you sent in March 2015 contained a legal form. It was one you thought the public defender should use in proposed orders to request more lenient sentences. But you failed to get copies to the Broward State Attorney's Office until many days later. Partly as a result, the State Attorney's Office filed a motion to disqualify you from all pending criminal cases. You denied the motion as legally insufficient, but the problem did not end there. This situation led to the second matter outlined in the charges against you. After you denied the motion to disqualify, the State Attorney's Office soon filed a petition with the 4th District Court of Appeal. That petition sought to disqualify you from a list of 962 cases. It led to the 4th District issuing a show cause order, and the effect was that work in your criminal division was frozen, unable to proceed for a significant period of time. Despite the serious impact of delay, you failed either to recuse yourself sua sponte or to seek an administrative transfer. Instead, you remained in the division hoping for personal vindication. It was during this period of time that the Judicial Qualifications Commission first served you with a notice that it was investigating your conduct. In meetings at this time with the Judicial Qualifications Commission investigative panel, you acknowledged that the email you sent was a serious mistake. You apologized. You offer no excuses. Yet, despite these interactions with the JQC, you compounded your misconduct in ways that led to the third matter in the charges against you. In August 2015, in open court, you lost your temper in a series of exchanges. You referred to the list of cases pending in the 4th District as, quote, disingenuous, end quote. You characterized the legal effort to disqualify you as, quote, a lie from the pit of hell, end quote. You said it was a fraud upon the district court. You called the person who compiled the list an idiot and publicly wished that the 4th District would punish that person. Judge Contini, the attorney who compiled that list was not present in the courtroom during your tirade, yet you chastised her by name and accused her of making misleading and fraudulent allegations. Those are serious charges to level against an attorney, as you certainly know. Yet you made them based on little more than personal anger. In another instance, you threatened a state attorney with contempt of court and accused him of misbehavior. You ordered the bailiffs to escort the state attorney from the courtroom after the exchange. Only after these things occurred did you finally seek an administrative transfer. When the JQC confronted you with this additional conduct, you again offered no excuses. This time you admitted that it personified incivility. In its findings and recommendations, the JQC suggested that you were a new judge at the time. It found that you underestimated the process of transitioning to the bench. To your credit, you have admitted the nature of your misconduct and accepted full responsibility for it at every stage of the proceedings. The JQC concluded that you expressed sincere remorse. Furthermore, you took steps to remedy the ethical breach caused by your initial ex parte communication with the public defender. You did so by notifying the state within a week. The record further reflects that you have offered apologies. You also have agreed to undergo mental health treatment and seek judicial monitoring from experienced judges. Were it not for this mitigating conduct, we would have been inclined to impose more severe sanctions here today. I say that to underscore how serious we view your misconduct. It is very serious indeed. Your actions damaged public confidence in you as a judicial officer and in the court as an instrument of justice. In sum, your misconduct struck at the very roots of an effective judiciary. And that is the reason why we summon you here today, to be publicly reprimanded in open court in a way that can be watched by anyone in the state. Finally, Judge Contini, we encourage you to review the prior disciplinary decisions this court from time to time has published. You will find many that have involved a single breach of ethics during a judge's career, with none that followed afterwards. We hope that this also will be the case with you. If it is not, we offer you a firm warning now. You also will find a lesser number of cases in which judges did not learn from their mistakes and committed a second violation. We advise you to remember what our prior cases have consistently held. Another ethical breach by you will be viewed far more harshly. Your public reprimand is concluded, and you may leave the court.